I sure did. I had 3 pages of objections to her failure to produce evidence. 3 pages of her of evidence of her failing to produce
Mr.
evidence.
Kelly, you need to calm down.
Mr. Kelly, we had several phone conversations in an attempt to resolve this matter, correct?
Objection, Your Honor. Discussions of settlement are not relevant and they can't be brought up in this courtroom.
He didn't ask you about what the terms of that settlement was. He asked you.
Yes.
And we discussed discovery and other matters in the process of that, didn't we?
Yes.
Okay.
And I specifically told you that they hadn't provided any discovery to date.
You understand that I wasn't the attorney for the vast majority of that.
Yeah, I understand that. But you mailed to me, you hand delivered to me responses to my second responses, but you didn't file them with the clerk. They're not in the clerk's record. The clerk provided me with a complete record last week. It's right there, and there's no response from you. There's nothing in there from you in this case. So you did not submit the documents to the clerk of the court. You gave them to me at the jail. You hand delivered them, but you did not file them with the clerk of the court according to that record there.
All right. But you don't dispute that you had the response. You
I
didn't
did
like
have the response, yes.
But you got it.
Can you prove what was in those responses?
You don't get to ask questions, Mr. Kelly. You've already had your time with Mr. Harrington on the stand. You respond to questions when you're sitting in that chair.
Objection.
Do we understand each other?
Objection.
What's the
For
objection?
the relevance of his question.
The relevance of the question you've already answered.
This line of questioning, what's your next question, Mr. Harrington?
May I go forward, John?
You may.
And did I have discovery here at the hearing, although you didn't like it and objected to it? Did I have the discovery at the hearing for your use if you wanted it?
Do you have proof of that? No, I don't have any evidence that you had it available to me. No, sir, I don't.
Do you not recall that I pulled the thumb drive out and plugged it into the computer and started showing you such evidence?
An audio recording was the only thing that that was about.
And you stopped any further processing of that. Is that correct?
About that audio, yes, because I was objecting to you introducing that piece of evidence into court. I wasn't objecting to your, I wasn't, the relevance of that audio recording was whether or not you were going to be able to introduce it into evidence. You never said to me, here's the discovery you requested, Mr. Kelly. It's available. You never told me the rest of your discovery is right here on this thumb drive if you need it, or would you like to review it, Mr. Kelly? You never said that. You tried to imply that you did, and you keep doing it, and you didn't do it.
Mr. Kelly, your voice. Please lower it. There's no need to be pointing your finger at Mr. Harrington either.
Mr. Kelly, did you subpoena those video records from us to appear at court with them?
Yes, and she produced a doctored rendering of that audio.
So what you requested was presented for the court, and you chose not to listen to all of it.
No, sir, that's not what happened. What happened was my second request for production of documents, you responded to. That's not what you're talking about a subpoena. We're not talking about the subpoena anymore. We're talking about your failure to respond adequately to the production of records pursuant to the rules of the court and the discovery in the Civil Practices Act. We're not talking about the subpoena anymore, Mr. Harrington.
Are you through? I don't wish to interrupt you. Did you file any motion to compel on the second set of discovery requests that you're citing today?
I had no opportunity to. I did vocally ask the judge or object to your, at what point in time, you provided me the discovery on the Friday before the Monday hearing. At what point in time would I have had an opportunity to file a motion to compel your untimely responses, your untimely and deficient responses?
You received those within the 30 days that you had requested. You received my response, whether you agree with it or not, you received my responses to that within the 30 days.
No, sir. You delivered your responses to me on December 6th, and my motion for those requests for those discovery was on November 3rd, outside of 30 days.
You understand that when you file these things, they have to be transmitted to me. Are you not knowledgeable about the 3-day rule? If you aren't, that's fine.
Your client made no meaningful effort.
Respond to the question that's posed.
No, I'm not familiar with the 3-day rule.
Okay. Did you ask this court that day to continue that final hearing because of that?
Yes, I did. I objected to this court, that hearing being proceeded on the fact that she had not produced any evidence whatsoever. And you just shook your head and you denied my motion to compel her to produce evidence. I sure did. I had 3 pages of objections to her failure to produce evidence. 3 pages of evidence of her failing to produce
Mr.
evidence.
Kelly, you need to calm down.
Did you ask for an extension of time for discovery, or are you aware that there's a general rule that you file discovery within 6 months of the initiation of the responsive pleadings?
Oh, I'm 100% clear on that. Judge Caulfield failed to enforce the rules of the court and failed to enforce in 30 days as the rules of the court require. The rules of the court require him to rule on motions within 30 days in this county. He let things languish for 7, 8 months before he would rule on them. So no, every meaningful effort that I made for a month, I tried to compel her through good faith contact, good faith discussion, asking her and her attorney to let's talk this out, let's get this done. And when they failed, I filed a motion for a hearing for a pre-conference discovery conference that you ignored for 6 months. So I was following the rules of evidence. I was following the rules of discovery. Cindy Hetzer, James Rockefeller, and James Caulfield were not.
Mr. Kelly, I'd advise you not to point your finger at me. You understand? And to lower your voice. I've cautioned you and cautioned.
Look, watch. Oh,
Why am I the only one that has to follow the rules?
here comes the ballot.
Why am I the only one being obligated to follow the rules, Your Honor? Why am I the only one being forced to prove? He knows what he filed, but now I have to prove what he filed, and I've got to prove what she filed, and I've got to prove what I filed. Why am I the only one that has to prove that I did something? And they don't have to prove that they did it. They can make an assertion, and if I don't prove that they didn't do it, then I don't understand. How is this fair? All they have to do is deny something, and it's okay with you. How is that fair? And if I deny something, I have to prove it. What's your next question, Mr. Harrington?
Well, going back to the question I asked, did you ask for any extension of discovery beyond the original 6 months?
I followed every rule of discovery that I was aware of. I made every single objection that I could make, that I knew to make. I made it orally to him. I cited pages and pages and pages of case law that mandated he dismiss her claims based on her failing to put in forward any meaningful effort to produce discovery.
Once more, my simple question.
I've answered your question, Mr. Harrington. I gave you my answer to your question.
The question I asked was, did you ask for an extension of discovery?
Asked and answered.
Mr. Kelly, respond to the question, please.
Would you like me to repeat what I just said? I made every single objection and filed every motion that I knew to. I raised every single point of contention that I knew to. I objected to her failing to respond to once the judge denied my motion to compel her to produce evidence, he silenced me. He's already ruled. So no, I didn't do anything beyond his order.
And I'm sorry, I know you, but you did not. You're saying you did not ask for an extension of discovery.
The judge had already ruled.
I think that's all I have. All right.
Do you have anything else, Mr. Kelly?
Yes. I'd like to recall John Harrington.
For what purpose, Mr. Kelly?
Redirect.
I'm not going to allow it.
He asked me questions, and I like to rebut those questions.
I'm not going to allow it. Anything further in regards to this motion?
No.
Argument? Do you have anything, Mr. Harrington?
No, sir.
I have an argument. I don't have any more witnesses, but I have an argument.
Okay, I was just asking Mr. Harrington if he wanted to present evidence to the court, Mr. Kelly.
I just wanted to make sure it's clear that my stating that I don't have anything else is only related to don't have any more
And I heard you, sir.
testimony.
I heard you, sir. Now you can make your argument.
(911)26 permits discovery regarding any matter that is not privileged or irrelevant. And before the plaintiff can make an objection that isn't related to privilege or relevance, they must first seek a protection order. In order to seek a protection order, they must first seek a conference with me pursuant to Rule 6.4B of the Georgia Unified Rules of the Superior Court, and which states, prior to filing a motion seeking a resolution of discovery dispute, shall confer with opposing counsel. They did not do that in response to my second request for production of discovery. They failed to respond in accordance with the rules of the court. They failed to do that. The rules of the court also state that in order for them to raise an objection of duty or obligation not required by the CPA, or unduly burdensome, or defendant may obtain from other sources, vague, ambiguous, broad, burdensome, or impossible, confidential, trade secrets, patient confidentiality, continuing investigation by the plaintiff. What is that? In order for her to raise any of these 13 objections, she must first seek a protection order. In order to seek a protection order, she must first seek a conference from me to resolve these disputes. She failed to seek a conference with me to resolve these disputes. She filed an untimely response because she failed to seek any dispute. Now, it also states that the rules of the court states that in order to make any objection, they shall be addressed to the specific and not be made generally. Now, her responses are all general. He lists in his responses that was not filed properly with the court, at least by the time that she gave me this record. He listed in his responses that these objections, he's like, we make these general objections, and he lists the 13 objections. And then in his next paragraph, he says, in response to these discovery requests, we invoke all 13 objections. He's not allowed to do that. The rules of the court states that he can't do that. She failed to respond properly to my second discovery responses. I didn't have time because his untimely response that was deficient by the rules of the state of Georgia and the OCGA, the code sections governing the Civil Practices Act, they did not make the proper objections or proper procedures. They did not follow the proper rules of the court to be able to raise these objections. And then I'm being asked to prove that he submitted it to the court. I subject that he needs to prove that he properly submitted it to the court and that he followed the rules of the court. I'm telling you he didn't.
You through,
Yes.
Mr. Harrington?
First, Your Honor, I would suggest that he has not followed the rules by asking for an extension of discovery. However, he has admitted that he got the responses. He admitted on the stand that we discussed it on the phone several times before we got to the hearing on December 9th. He could have asked this court to continue that hearing based on that. He did not. The court clearly pointed out it was a final hearing. He disputes this, but he has put evidence up that has been provided to him both by Mr. Rockefeller and myself. And he admitted on the stand a few moments ago, we discussed the discovery and all disputes. I did not ask about settlement. I asked if we discussed discovery and resolution, but I didn't ask any particular points about resolution. I understand and I have sympathy for the idea that he may not understand all the rules of court, but he has had his bite of the apple. And frankly, to come back after all of the litigation, much of which I was not involved with, to throw it all out with a motion to dismiss would be a great disservice to these children who need to move forward and my client. Now, I respectfully request that the motion to dismiss not be granted.
All right, anything further, Mr. Kelly, in regard to this motion?
Absolutely. So he says that I didn't raise any objections, but I filed a motion to dismiss at the very first available opportunity that I had following his deficient answers or responses. Friday night or Friday afternoon at 2 or 3 p.m., I get an envelope from him with his answers. The next Monday, the 9th, was when I submitted the very first opportunity that I can, my objection. And maybe I don't know the term, but because I misnamed it, I don't know if it's because I didn't name it properly, you're going to dismiss it, or he's going to, because I didn't say I request an extension. I wasn't requesting an extension. I didn't fail to follow the rules of discovery. He did. I've raised the issue that he's failed to follow the rules of discovery. He didn't raise that issue with me. I've raised it with him. This motion to dismiss raises all the legal arguments with sound case law, Stoll versus State Farm, Cook versus Lannister, a willful refusal to participate in any meaningful way with the discovery process represents a conscious and intentional failure to act established by Stoll versus State Farm. The appropriate remedy is a dismissal of the plaintiff's claims as established in Cook versus Lassiter, 159 Georgia AP 24, 1981. And because the plaintiff failed to comply with the rules of the court under which she was obligated to operate, she has no grounds to object to this motion to dismiss, Wimberly versus Karp, 1988. He admits that he sought no conference. He admits that he sought no motion for a restraining order. He admits that. He admits that, and the rules are clear. The rules in plain language state that in order for him to seek a protection order, he must, or in order, Prior to filing a motion seeking a resolution of a discovery dispute, he shall comply with opposing counsel and then file a motion for, he needed, the law requires that he filed a motion for a protection order to be able to raise the objections that he raised, and he didn't do that. And she made no meaningful effort whatsoever, whether it's request for admissions, my first production of evidence, my second production of evidence, she's made zero meaningful effort. And I raised this issue in my motion to compel that you dismissed at the beginning of the final hearing. She didn't do anything to provide any evidence. Nothing. Nothing. She didn't provide one document, not a single document as requested by the Civil Practices Act. She didn't provide anything.
All right. Court's gonna take this motion under advisement. I'll review parts of the record before I make a ruling. Mr. Kelly, looking at the motion to dismiss, that reflects it was filed on, December the 16th. It appears to the court to be verbatim with the motion to dismiss that was filed on December the 11th. Do you agree with that?
I don't know, if you give me a minute, I'll look.
Sir?
I believe it is.
No, sir, we do not believe. You need to verify or deny, please.
No,
Would you like to review the court's notebook of the two motions to make that determination, Mr. Kelly?
no.
I've got copies of the filed motions, marked file.
I don't know. I don't see how. I don't understand why this one would be stamped the 16th and the 10th, because I have my record here shows that I faxed it.
And I'll be glad to show you the two motions that are copies of what's in the record. And as I stated, it appears to be, they appear to be the same thing.
I think you're right, Your Honor. I believe it is.
So the motion the motion to dismiss filed on the 16th, can that be withdrawn?
Can I look at the court's?
Stay right there. Somebody come and get it.
Can I see the one that the other one that you have? I have that one as the December 16th.
Leave that right there so he can make a comparison, Mr. Simpson. I need.
Yes, sir, they're the same. I don't know how that happened.
Do you withdraw?
Yes.
One? Which one do you withdraw, sir?
The one that we haven't heard yet.
All right, then the December the 16th is, motion to dismiss is withdrawn. Thank you. Court will issue an order on that, in that regard.